What you're about to witness is one of the most emotionally devastating sentencing hearings to ever play out in a Texas courtroom. Two young women, newlyweds, barely started their lives, gone in an instant. And the man responsible, he had been down this road before. Not once, not twice, but 3 times, 3 prior DWI offenses, and he still got behind the wheel. Still drove drunk for hours across multiple cities. Still made that choice. We're talking about Salvador Gomez, a 52-year-old man who started drinking at 5:30 in the evening, downed 8 or 9 beers in Port Arthur. Then drove 30 minutes to a strip club in Beaumont, kept drinking, took shots, and somewhere after midnight decided he was fine to drive home. He wasn't fine. He was never fine. And 2 families are now shattered because of it. The victims, Camille married just 19 days before she was killed. 19 days. Her husband, Chris, was in that courtroom. So was Boston Carr, the young man who had just begun building his life with another victim, who told his father he had to do something, go somewhere, only to be told there was nothing he could do, nowhere to go. Today, Judge West has to weigh mercy against justice. The prosecutor is asking for the maximum 40 years. The defense, well, you're going to want to hear what Gomez's own attorney tried to argue. Stay with us, because this one is going to hit hard.
How long has y'all been married before she died?
Only 19 days.
I'm sorry you have to be here, Chris. I'm sorry all these people that are in the courtroom have to be here. You and I spoke about this case, the legal side of it, and what can possibly happen. What are you asking Judge West to do today?
I think the only thing that can be done is the maximum sentence. I think that's the only way that any kind of healing can be done. From just on my end and from the 1,000 lives that were affected by this senseless tragedy.
Thank you, Chris. I'll pass it to Sharon.
Any questions?
No question.
Thank you. You may call your next witness.
State called Boston Carr.
Go ahead.
Thank you, Your Honor. Mr. Carr, would you identify yourself for the jury and tell us what you do for a living? I mean, for the judge, and tell us what you do for a living, please.
My name is Boston Carr, and I live in Beaumont, Texas, and I work for Bierce Industrial, an industrial sales company.
And how old are you, sir?
I'm 22 years old.
How did you find out that Camille had been killed?
I was asleep, and my dad busted into my room, and it was about 4:30, 5 o'clock in the morning.
Let that land for a second. 19 days. Chris Stacks had been married to his wife for just 19 days when she was killed by a drunk driver. That's not even 3 weeks of marriage. They hadn't even had time to settle into their new life together, and it was ripped away in an instant. And here he is, composed enough to stand in a courtroom, look a judge in the eye, and ask for the maximum sentence. Now, when Chris says 1,000 lives were affected, that's not hyperbole. Think about it. 2 victims means 2 sets of families, 2 sets of friends, to faith communities, co-workers, neighbors. The ripple effect of drunk driving fatalities is almost impossible to quantify. And what strikes me about Chris's testimony is the restraint. No screaming, no breaking down completely. Just quiet, dignified devastation. Sometimes that kind of pain speaks louder than anything else ever could. Remember his words as we move through the rest of this hearing.
Thank you, Chris. I'll pass it to Sharon.
Any questions?
No question.
Thank you. You may call your next witness.
State called Boston Carr.
Go ahead.
Thank you, Your Honor. Mr. Carr, would you identify yourself for the jury and tell us what you do for a living? I mean, for the judge, and tell us what you do for a living, please.
My name is Boston Carr, and I live in Beaumont, Texas, and I work for Bierce Industrial, an industrial sales company.
And how old are you, sir?
I'm 22 years old.
How did you find out that Camille had been killed?
I was asleep, and my dad busted into my room, and it was about 4:30, 5 o'clock in the morning. And I remember waking up, and he just said, "The girls got in an accident." My first thought was that they had to be okay. There was no way something like that could happen. And I immediately asked, "Are they okay? What hospital are they at? You know, what ER are they in?" And all my dad could say was, they didn't make it. All I could say was no. Just no, no. And I jumped out of bed and I still just couldn't believe it. There's no way. And I got dressed as fast as I could and I ran downstairs and I didn't know what I could do. I thought there was something maybe I could do. And my dad just told me, he said, Bubba, there's nothing you can do. There's nowhere you can go. Can't do anything.
And since this has happened, how's it affected you, Boston?
I had begun building my life with Camille and my life plans and our life that we were building together and we had just begun to build together was just taking off. And the one thing that I thought I had done right in my life was deciding to marry Camille. And with that gone, I feel so lost in like this life that I was supposed to have has been taken away from me.
Boston Carr is 22 years old, 22, he said, and I want you to really hear this. The one thing I thought I had done right in my life was deciding to marry Camille. He had found his person. He had a plan, a future, and all of it was erased in a single night because one man couldn't call a cab. Here's what I want you to think about. Both Chris Stacks and Boston Carr, to grieving men from the same tragedy, asked for the exact same thing independently. Maximum sentencing. No hesitation. No wavering. They didn't come in screaming for blood. They came in with broken hearts and a calm, clear demand for justice. Now, here's a question for you watching. Drop it in the comments. If this had happened to someone you loved, what would you be asking that judge for? Because I think most of us already know the answer. The prosecution's case for maximum sentencing is building fast. But we're about to hear from the defendant himself, and what he says is going to raise some eyebrows.
I'm asking the same question that I asked Chris. What do you want to see happen here today?
Full sentencing underneath the law, that's possible.
And that's actually not enough, is it? Nothing can fix it.
I don't believe it is.
I understand. Thank you, Mr. Carr. I'll pass it to Cheryl.
No questions.
Thank you.
I have no other witnesses to call in punishment, Your Honor.
Thank you, Mr. Nichols. Mr. Young, do you have any witnesses?
Yes, Your Honor, we would call Salvador Gomez.
All right, Mr. Gomez, if you'll just get them close over here, please.
Now, when we were preparing for the trial, you've never been convicted of a felony anywhere, correct?
That is correct.
So you technically qualify for probation. Are you asking this court for probation?
No, sir, I'm not. I don't think it's appropriate. I'm taking full responsibility for my actions. And that's why I don't think it's appropriate for me to even think about it.
So when the probation officer included all that in the report.
Okay, pause. This is a critical legal moment that you don't want to miss. The defense attorney just confirmed something remarkable. Salvador Gomez technically qualifies for probation. Under Texas law, if a defendant has never been convicted of a felony, they can be eligible for probation even in serious cases, and the probation office is required to include that option in their pre-sentence report regardless of the crime. But here's the thing. Gomez himself said no. He told the court he's not asking for probation. He said it's not appropriate and that he's taking full responsibility. Now, is that genuine remorse? Or is it a calculated legal strategy to appear more sympathetic to the judge? Because in sentencing hearings, how a defendant presents themselves can absolutely influence the outcome. Judges are human. They respond to accountability. What's interesting is what comes next. Because the prosecution is going to challenge whether Gomez's version of taking responsibility actually holds up under cross-examination. And trust me, it gets tense.
All that in the report about that's nothing you asked for. That's just something they include.
That is correct, yes.
So I think the last thing is there anything you want to say to the families of Ms. Eisenhower this morning?
Yes, I will. To the Eisenhower family, to the Marty family, Mr. Stacks, Mr. Carr, there's nothing that I can say, nothing that I can do to bring your loved ones back. Ever. The remorse and the shamefulness that I feel about this. It's unthinkable. Nothing that has happened to me compares to the destruction that I've caused in your life. I've destroyed your life. And nothing that my injuries, that doesn't even compare. I can't even fathom what you all are going through. I really don't. And I've thought about this for over a year. And I just can't come up with a proper thing to say, but what I've said. I don't wish this upon even my worst enemies, because I know you all are hurting beyond imagination. And like I said, I wish I could do something, but I can't.
Have you asked for forgiveness from your personal Savior?
Yes, I have. I ask for forgiveness for my Lord and Savior Jesus Christ, and I'll have my judgment day with Him one day. Trust me, I've said it to myself a bunch of times, and I've said it to Him too. Why didn't you kill me instead of them? I would have preferred that, but He did what He did, and I'm sorry. I'm very sorry.
Pastor Rich.
Thank you. Any questions, Mr. Nichols?
Yes, Your Honor.
Did you catch that? The prosecutor asked Gomez about his prior DWI convictions, and Gomez said it happened to him. Happened to him. As if drunk driving is something that occurs like a weather event, a thunderstorm, something outside his control. The prosecutor immediately called it out. Not you did this to them, it happened to you. That's how you see this. This is one of the most revealing moments in the entire hearing because it exposes a subtle but deeply important distinction. True accountability means saying, I did this. It means active ownership. But the language Gomez used even unconsciously frames himself as a victim of circumstance rather than an agent of destruction. And the prosecutor wasn't going to let that slide quietly. 3 prior DWI. He told kids at schools about the dangers of drunk driving. He knew. He knew better than almost anyone what the risks were, and he still drank for 7+ hours and drove. The cross-examination is exposing the gap between what Gomez says and what the facts actually show.
Yes, Your Honor. Mr. Gomez, how many DWI convictions did you have before this night?
3.
2 here in Texas and 1 in Virginia, is that correct?
That is correct.
And on those occasions, you were put on probation?
Yes, sir.
And as part of probation for DWI, I'm sure they taught you the risk when you were wanting to get out and go speak to kids and teach them about drinking and driving. You wanted to show them that you don't think it could happen to you, but it happened to me. That was your words, correct?
Yes.
It happened to you.
Yes.
Not you did this to them, but it happened to you. That's how you see this?
Oh, no, sir.
How old are your children?
27, 21, 20, and 18.
And if, God forbid, they were taken from you because of someone drunk, intoxicated driving, what would you be asking the judge to do?
I will let the justice system look at all the facts and the judge, and for her to decide, or them to decide what is the right thing to do, the right decision.
When you were taking shots at the strip club and stumbling over your chair, what was going through your mind at that point?
Not a whole lot.
And then after that, you decided to get in your truck and drive 20, 30 miles back to where you live off of West Port Road. Correct?
Yes, sir.
And your evening started at the Taqueria in Port Arthur,
Yes, sir.
where you drank 8, 9 beers between 5:30 and 9:30. Is that accurate?
Yes, sir, I think so.
And you left the city of Port Arthur after having had 8 or 9 beers and drove the 30 minutes or so to a strip club in Beaumont. Is that accurate?
Yes, sir.
And for several more hours, you continued to drink. You took shots and you drank beers.
Yes, sir.
And then after about 12:30, 12:45 in the morning, you got in your truck to drive back to West Port Arthur Road.
Yes, sir.
And you're asking this court to give you some mercy for your choices.
I'm asking the courts to review the facts and make the right decision. That's what Gomez said when asked if he was seeking mercy. And look, on the surface, that sounds measured and respectful. But listen to what the prosecutor just laid out in brutal sequential detail. 8 to 9 beers, starting at 5:30 p.m. in Port Arthur. Drove drunk 30 minutes to a strip club in Beaumont. Continued drinking for hours. Took shots. Was seen stumbling. Then got in his truck after 12:30 a.m. and drove again. That's not a momentary lapse in judgment. That is a series of conscious decisions made over the course of an entire evening, each one giving him another chance to stop, to call someone, to hand over his keys. He had hours of opportunities, and he chose wrong at every single turn. So when the prosecution says undeserved mercy to the guilty is an injustice to the victims, they're not being dramatic. They're being precise. The facts don't just speak for themselves here. They shout,
Sir, I'm asking the court to review the facts. And the judicial system, they can make the right decision on what they want to do, sir.
I'm sure they can. Pass, please.
Anything else, Mr. Young?
One question. Mr. Nichols referred to your prior offenses for the misdemeanor of driving while intoxicated. When was the last one?
In 2005.
Pass it.
Anything
No
else?
other questions, Your Honor.
All right, thank you.
I understand there's times for mercy, there's times for compassion, Your Honor. But I think undeserved mercy to the guilty is further cruelty to the victims. And they've been through everyone's worst nightmare. 20 plus 20 is 40, and that's really not enough, but that is the maximum allowed under law, and that's what I'm asking you to do on behalf of the Marty family, the Eisenhower family, Christopher Staggs, Boston Carr, and their entire faith community. The one reason all these people, including the Gomez family, are here in this courtroom today is because of what he did, what he chose to do. And it is a tragedy up and down. And so I'm asking you to protect the citizens of Jefferson County from any chance that this could ever happen again from Mr. Gomez. Thank you, Your Honor.
Thank you. I have a question, Mr. Nichols, with regard to deadly weapon finding. I'm looking at the indictment, and it doesn't read that there's a deadly weapon.
Right, I don't believe it does, Your Honor.
Okay. And it's not something I looked into. Is that something I can still find if the indictment doesn't say it?
Yeah, I don't have an answer for that.
Okay. Do y'all know? If it's not, if it's not in the indictment?
The court would have to find, it is permissible without a request, without it being included in the indictment. However, the court would have to point to specific evidence that it was used or intended to be used as a deadly weapon.
Okay.
And I would argue to the court that perhaps, I mean, if there had been other evidence, but there's really no evidence admitted upon which the court could make such a finding, so I would ask the court not to find that. But I will represent to the court as an officer of the court that it is not absolutely required that it be included.
Okay. I really
this
didn't.
part of the hearing is crucial from a legal standpoint, and it's easy to miss if you don't know what you're looking at. The judge is raising the question of a deadly weapon finding, and this matters enormously for how Gomez will serve his sentence. In Texas, when a judge makes an affirmative finding that a deadly weapon was used in the commission of a crime, the defendant becomes ineligible for parole until they've served at least half of their sentence. Without that finding, they could potentially be eligible for parole much earlier. The question here was whether the deadly weapon finding needed to be included in the original indictment, and the answer, as the attorneys are clarifying, is that it does not have to be in the indictment. The court can make that finding based on evidence presented. The judge is essentially asking, can a vehicle driven while intoxicated constitute a deadly weapon? The law says yes, and the evidence in this case makes that conclusion almost unavoidable. This finding is about to significantly impact how long Salvador Gomez actually stays behind bars.
I really didn't think so. I just wanted to make sure. I would think I guess, Mr. Young, would you disagree with the information that is provided in the pre-sentence report that everyone has agreed that I review, that I could use that as far as, since I've taken judicial notice of that, the letters and everything else, that would be, would you have an objection of me using that if I were in fact to make a finding of a deadly weapon?
Your Honor, I think the court can consider all evidence before the court, and if there is evidence that the court can point to that says this supports the finding of deadly weapon, obviously we can't contest that.
Okay. First, I really do want to thank everybody for being here. We don't have full courtrooms like this. These, just as both of the attorneys said, these are some of the most difficult cases that any judge has to deal with for many reasons, obviously. Mr. Gomez, had you been in, well, I'm not sure that it would matter, but had you been in here and this was your first DWI, there might be some sense of what your attorney was asking for me, which is true. I mean, I have to detach myself from the emotional part, which is, it's impossible, but it's required, and I do the best I can to do that. And there are things about you and your life in the past that are good. There are things that the 3 prior DWIs should have taught you. Your age, you're 52 now, 53 now. You know, it's the 3 DWIs previously, even though they're older, and your age, it's not the establishment's fault. Did they violate the law? Absolutely. You're a grown man. Grown man. Got into a vehicle, and you know from your history, you know from your age, you know probably from telling your own children not to drink and drive, and trying to probably instill that in them, and you did it, and you did this. So at this time, in cause number 24, DCCR 1651, I'm going to find you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter with a vehicle. I'm going to sentence you to a term of 20 years in the Institutional Division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. I am basing that on all of the information that's presented in both the pre-sentence report, the attached reports from the officers, in addition to the letters from Mr. Stacks, who unfortunately had to drive up and see this in person, from what they had to use to identify these 2 precious young lives, that there's no way that there is any doubt that you used your vehicle in a manner capable of causing death, and that you in fact did that. In cause number 24, DCCR 1652, I'm also going to find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter with a vehicle. Sentence you to a term of 20 years. There will also be a deadly finding in that case based on the same information and evidence that I used in the previous one. That sentence will run consecutively to cause number 24, DCCR 1651. In cause number 24, DCCR 1653, I'm also going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated, third or more. Find those prior offenses true. Sentence you to a term of 10 years in the Institutional Division of the Texas Department of Corrections. That will run concurrently with the other 2 sentences. You will receive credit on these sentences for any time that you...
Judge West handed down the sentence, and it is as close to the maximum as the law allows. 20 years for the first count of intoxication manslaughter, 20 years for the second count, running consecutively, meaning back-to-back, not at the same time, 10 years for the felony DWI charge, running concurrently. That's a combined effective sentence of 40 years in the Texas Department of Corrections, with an affirmative deadly weapon finding attached to both manslaughter counts. What does that deadly weapon finding mean in practice? It means Salvador Gomez must serve at least half of each consecutive 20-year sentence before he becomes eligible for parole consideration. He will be well into his 70s at the earliest before he sees the outside world again. Now, some people will watch this and say, 40 years still isn't enough. Chris Stacks and Boston Carr said as much themselves. Others may point to Gomez's remorse, his willingness to plead guilty, his statement to the families. But here's what the judge made clear. 3 prior DWIs, his age, his experience, there was no excuse. He was a grown man who knew exactly what he was doing and chose to do it anyway. Twice, he killed someone. Twice, 2 young women. To families. To husbands left to rebuild lives they never planned to rebuild alone. That is the real sentence in this case, the one that has no end date. If this case moved you, challenged you, or made you think, let us know in the comments below. What do you think about the sentence? Was 40 years justice? Or should the law allow for more? Hit that like button. If this breakdown was valuable to you, share it with someone who needs to hear this story. And make sure you subscribe to the channel so you never miss another real courtroom breakdown. We cover the cases that matter, the ones that remind us what justice actually looks like when it's being decided in real time.
On these sentences for any time that you've been in custody that the law gives you the right to receive.
Comment your opinion, like the video, and subscribe for more real courtroom moments.